Hello, my name is Stephanie Hyatt. I am the president of the Jefferson County Pro Bono Lawyers. Welcome to our presentation today. This presentation is titled Transitioning from the Eviction Moratorium, a summary of the recent changes in eviction laws and resources in Washington State. For those of you who are joining us and are not familiar with Jefferson Pro Bono, it's a nonprofit organization that provides legal assistance to low-income individuals in and Jefferson County. We also host CLEs and presentations like this, as well as free legal clinics. And we also just started a new program through the Housing Justice Project, and we will have a staff attorney, which hopefully, if we have some time, we can introduce you to our new staff attorney at the end. Today's program will consist of 3 parts. The first part will have Steve Robbins presenting, and he will be doing a summary of the new bills and and the right to counsel for tenants, and giving us a look at the changes from the tenant's point of view or perspective. Next, we will have Sam Feinsen. He will be giving us a presentation from the landlord's perspective and advice for landlords. And then we will have Cherish, who will be giving us some information about how to apply for assistance and what resources are out there for landlords and tenants through rental assistance programs. So just to give you a short introduction to our presenters, Steve Robbins is an attorney at the Port Angeles office of the Northwest Justice Project. He graduated from Capital State University Law School in 1975. And prior to joining the Northwest Justice Project, he was a supervising attorney at Columbia Legal Services and a managing attorney at Advocates for Basic Legal Equality. I do know that Steve has served on the board for Jefferson Pro Bono for a while in the past. I'm sure he has some other community participation and involvement, but I internet stalked him for 15 minutes and I couldn't find it. But maybe he can tell you some more about that himself. Sam Feinsen is a private attorney. He's practicing in Port Townsend at Fiber Feinsen PLLC. His practice focuses on criminal defense, family law, dependencies, and landlord-tenant issues. Sam became a Washingtonian in 2005 and then graduated from the Seattle University School of Law in 2012. In addition to practicing law, he also serves as chair of the Port Townsend Active Transportation Advisory Board and is a member of the Northwind Art Board of Directors. And finally, Cherish Cronmiller is the executive director of OLICAP. She has extensive experience working with and managing community action programs, including the Miami Valley Community Action Partnership and the Dayton Metropolitan Housing Authority. Cherish graduated from the Ohio State University School of Law in 2006 and became a member of the Washington Bar in 2021. She is in other community programs or involved in other community programs as well, including the Olympic Community of Health and Port Townsend Noon Rotary. So thank you very much to our 3 presenters. We will take questions if you're able to put them in the chat. If you have specific questions for the presenters during their portion, I will try to get those to them. And then if you have any general questions for the panelists, then we'd ask that you save those for the end. And then finally, for our attorney participants, if you're wanting to get a CLE credit, just make sure to send me an email with your name and bar number. My email is stephaniehyatt@icloud.com. Okay, and with that, I'm going to hand it over to our first presenter, Steve.
Okay, thanks a lot, Stephanie and Sean. I really appreciate you asking me to do this. It's a really important thing and it's going to affect a lot of people. Okay, as I'm sure everybody out there knows, the Washington legislature and Governor Inslee created a program to avoid evictions over rental disputes. There's been major changes in the landlord-tenant law. The two that we're talking about today is right to counsel, RTC, and the eviction prevention program, eviction resolution program. The relevant law is House Bill 1236 and Senate Bill 5160. And when you're doing this, you also need to look at local Clallam and Jefferson rules. They both have standing orders and right to counsel orders. The first thing I want to tell you is that in order to qualify, you have to be indigent. Indigent is defined by the statute as either on public assistance, things like food stamps or disability benefits, or have an annual income after taxes of below 200% of the federal poverty level. Okay, so a couple important things to remember. Well, I think I forgot the most important thing. Just yesterday, Governor Inslee extended the bridge moratorium from September 30th to October 30th, which is certainly going to give everybody participating in this a lot more time to get prepared. So the legislature funded a program that includes DRC, dispute resolution centers, Housing Justice Project with VLP, NJP, and also created a thing called Eviction Prevention Unit. These are lawyers that were hired by NJP to represent clients in eviction hearings. We just recently hired a Gonzaga law graduate, Hannah Harrison, and she'll be starting in 2 weeks. So the way the program is set up is that Superior Court, DRC, VLP, and NJP will be working together. We'll be working together to try to resolve evictions based upon non-payment of rent through the non-judicial process. That is basically the eviction resolution program. The property owner, prior to filing a summons and complaint, has to strictly comply with notice, service, and certification requirements in the statute. What that requires is that the landlord, property owner, meet with DRC, the tenant's lawyers, and try to come up with a resolution of the back rent owed and future rent. After that meeting, DRC will certify to Superior Court what happened with the filing at that meeting. The DRC certification, if they're unable to make contact with the tenant after 3 attempts, they need to note that in the certificate form to Superior Court. If the tenant declines and refuses to participate, the property owner has 14 days before he can file, and then they can file an eviction action. When a case gets through to Superior Court at the initial hearing, once the RTC, the right to counsel statute, is implemented, and what that means is basically is that OCLA, the Office of Civil Legal Assistance, has certified that the particular Superior Court has done everything necessary and are ready to appoint lawyers and the funding lawyers to represent indigent clients. What will happen at the first hearing, the court will first inquire if the respondent is indigent. If so, if they want appointed counsel. If that's so, the case will be continued to allow the tenant to contact DRC and HJP or NJP to request representation. There is one number I probably should give right now that's really important. NJP has set up a hotline called the Eviction Defense Screening Line. This is a dedicated line in Seattle that will take all the referrals from the various superior courts. The number is 1-855-657-8387, open every day from 9 to 1 and 2 to 4. If you can't get through, you can always leave a message and they will get back to you. The upon the referral to DRC, I see the question there. It's in the standing orders, whether the continuance is codified or not. The various superior courts have issued standing orders that details the process. You can find those standing orders either at the Washington Court's website or at the individual superior court websites. So the DRC will get a referral contact information with the tenant's name, the property owner's name. If the property owner has an attorney, they will contact them and try to set up a meeting to discuss a negotiation over the rent owed and future rent. And there is one thing to really important to remember. The new statute does create a right to counsel, but it also creates what can be best labeled as a no cause prohibition for evictions. You can still evict for many reasons. It's codified at 59.20.080, but there has to be cause. If there's not a cause for the eviction, then the case will be dismissed. So those cases can proceed. The eviction resolution program is solely devoted to dealing with rent, COVID issues, things like that. Okay, so both statutes require a good faith effort by both the property owner and the tenant to resolve rent issues. They do that through notices. Each court has very specific notices detailing what the tenant can do to get representation. The DRC is being funded by the state to hire specialists to do this work and to have available personnel. So the first thing you look at is, did the property owner comply with the standing order or pre-filing notice requirements? That requires the property owner to obtain a certificate of participation with the DRC. The participation means a mediated agreement with a repayment plan, and there are requirements for the payment plan, which I'll get into a second. And was there an effort to connect the renter with available resources? So non-payment of rent, evictions, and repayment plans. Unpaid rent between March 1st, 2020 and 6 months after the public health emergency ends is still continuing. These plans can be implemented. The plans have to be reasonable, only for rent owed. It can't be for other charges, and it cannot be more, unless by agreement, more than 1/3 of the monthly contract rental amount. The tenant has to respond to this one way or the other. Non-response, I'll get to that in a minute, is not acceptable. If the tenant doesn't accept the plan after participation, the landlord has to wait 14 days before filing a unlawful detainer. And then the property owner at that point has to properly serve notice under Washington statutes. The only exception to that is going to be transitional housing, a hotel, a motel, which only requires a 7 days notice with a notice detailing the hotline and NJP information. Failure of the landlord to comply with the plan requirements is a defense to a UDA action. When you're before the court, the trier of fact may take into consideration decreases in income or increases in expenses due to COVID. Another thing you have to look for in the plan, did the plan include aspects of charges, utilities, late fees, attorney fees, anything like that, waiver, anything like that is unenforceable and cannot be part of the plan. Now, if the tenant either doesn't participate or doesn't participate in good faith or doesn't respond, the property owner at that point has two options. They can proceed with a eviction action, or they can contact Commerce, State Commerce, and seek reimbursement for the landlord mitigation fund, but they can't do both. COVID rental debt is not an enforceable obligation until the property owner and the tenant have an opportunity to participate in the resolution program. Rent after starting in August, any rent paid starting in August must be applied toward current rent, not arrears, unless otherwise agreed upon. Rent owed after August 1st, in that situation, the property owner can't serve notice if the tenant makes full payment, or if makes partial payment as agreed upon by the parties, or if the tenant has a pending application for rental assistance that has not yet been processed. Post-tenancy under 5160. These rules will apply up to 6 months after the end of the public health emergency. The property owner may not report COVID debt to prospective property owners. The prospective landlord may not take under advisement adverse action based upon the COVID rent owed. Violation and no late fees. Violation of this will subject the property owner to possible penalty of 2.5 times the current rent plus court costs plus attorney's fees. So I see I'm running out of time. Let me real quickly go to the notice requirements under 5912.0303. Every 14-day notice has to have a form from the Attorney General office that gives in very good detail what the tenant's rights are and how to access them. Those would be the right to counsel, the clear, the eviction hotline, and dispute resolution contact information. Also, there's interpreter services under the statute that are available to indigent clients. And the notice has to say failure to respond may result in a detainer action. I think that's my time. Do I have to answer questions now or later, Stephanie?
We do have one question that popped up while you were speaking.
Okay, sure.
The question is, to clarify, right to counsel is based on income qualification. However, the eviction resolution program is a service available to all, regardless of income.
Yeah.
Correct.
No, it's only available to indigent applicants who either have income after taxes 200% or less of the federal poverty level, or who get food stamps or SSI or disability payments. So it's not a universal right to counsel. But I do have to note, Washington's great honor, we're one of the first, if not the first, to have a right to counsel statute.
And I have one more question here. Can a landlord compel a tenant to disclose public entitlement benefits received during the moratorium, such as unemployment benefits?
That would be and I should amend all this by saying this is a brand new statute, just recently created. There's very little, any case law about it. So a lot of this is going to be open to interpretation. I would say that would be part of the negotiations with the property owner and DRC.
Okay. And then I have another question. I think that might be easier answered by email.
Okay.
So I'll forward that. If Michelle, if you can give us or email Shauna at probonoloyers@gmail.com with your questions, she can forward that to Steve for you. And then I'm gonna turn it over to Sam to give us some more quality information. And we will also have some time at the end for questions for all the panelists as well, if anyone had more questions that they didn't get answered.
All right, great, thank you. Yeah, I want to note I'm providing sort of with a landlord's perspective here, but I would note I represent tenants from time to time as well, and I have in light of the new changes to the law. And I'd also note that really what I'm going to talk about is something that landlords and tenants need to keep in mind, because the goal here should be to avoid going to court whatsoever. Clear expectations from the tenant and the landlord are what I always counsel people to set up when they're screening a tenant, when they're thinking about renting, and when they're drafting a lease. And the upshot, really the biggest upshot of my entire presentation, I'm going to give you now and spoil the ending, but it's that a written lease is really in the landlord's best interest for sure. Maybe not the best thing or the most flexible situation for the tenant, but I think it's really helpful to both parties, establishing expectations and acknowledging each other's rights and responsibilities. So with that said, apart from the non-payment of rent issue that I think Steve really covered in great depth and really thoroughly, there are very few reasons now why and 16 to be in fact, to be specific, why a tenancy that is month to month, that has no specified period, can be terminated. I'll get into those a little bit. It used to be that on a month-to-month tenancy, it's sort of pre-COVID, and you could on a month-to-month tenancy with no written lease period, or whether it could be a written month-to-month lease, you could typically terminate a tenancy just by giving 20 days notice. And a lot of landlords made use of this provision. I've seen in the last couple months, several landlords attempt to make use of this old provision in the law that's no longer in effect. That's been wiped out entirely. And that's probably really on basis, admittedly, on balance, for the best, given the housing situation and the need for people to plan for the future. One of the things that tenants and landlords need to keep in mind, and this is why a written lease is so important, is that there are terminations without cause. A termination without cause being, by which I mean, for lack of any wrongdoing on the tenant. There are specific causes related to the landlord's needs, which include economic needs. If this just isn't working anymore, it's too expensive for the landlord to maintain. There's not enough, the rent isn't high enough. Certain terms need to be changed. If utilities need to be added to the cost because they've come too high, that's something a landlord has the flexibility to do. And I'll mention that a little bit later. But when you have a written lease right now, the new law allows you to terminate that lease without renewing it, as long as you have, number one, a set period of time that's either 6 months or 12 months. A lease that goes beyond 12 months needs to be technically under law recorded with the in the county where it's taking place. So I don't usually recommend that in a residential situation. This really pushes landlords to offering 6 and 12-month periods of rent. When you have a written lease like that at that situation, a landlord, if they provide 60 days notice in writing, and I'll talk about notice in a minute, that can be terminated without cause at the end of the rental term. And when we're talking about, and when I mentioned term, that's a very specific word that means a very specific thing in the context of the Landlord-Tenant Act. A rental term is a definite period of time, so a term of 6 to 12 months. Rental period, when it's used in the statute, typically means just the month to month. That rental period is that unit of time for which a tenant's paying rent or utilities or performing certain duties in exchange for being allowed to live there and possess the property that's rented. So when you have the 6 to 12 month rental term, you can end that tenancy with, and it really ought to be a written lease. Theoretically, I guess under the law, it could be a verbal lease, but then you get into issues about what people understood and what they didn't. So I always recommend that be written. And with 2 months notice, a landlord can say, we will not be renewing this lease, we will be terminating it. And that's what you need to either tell the tenant you're not going to live here anymore. That's also what you need if you're a landlord to change the terms of the lease. And that's really only something you can do once, unless you've strung along 6 month to month, and that's correct, Noah. If you strung along successive leases of 6+ months. And that's only if the tenancy has never been month to month. So there is some statutory exception for leases that were entered into between May 10th, 2021 and 3 months after the end of the pandemic proclamation that sort of extend this practice as well. But it's important to keep that in mind. But yeah, no, that's a very good point I'm seeing in the chat. That's a one-time deal if you don't. So a landlord really needs to make that determination. The recommendation is to, have a new lease, have successive leases. However, the majority of the leases that we see from that I've seen in the last few years of doing this, or the majority of tenancies, if they have a written lease, it's typically month to month. That's going to need to change, I think, for a lot of landlords' needs in terms of, the flexibility is no longer there in really any situation. But landlords really need to take a look at this because the causes for termination now are very limited. There isn't any kind of no cause termination. There are causes that are specific to tenant behavior. There are causes that are specific to landlords' needs. Those landlords' needs are very slim. So non-payment of rent, I think Steve covered it in depth. A default in payment after a 14-day written pay or vacate notice. I'll note there's a statutory form for what that notice needs to look like. There are also statutory requirements of the notice. You need to either hand deliver a notice to a tenant, and that notice needs to be conforming, or you need to post it on the rental unit and you need to send it certified mail to prove that it was received. It is possible and it is arguable, and I've successfully and also unsuccessfully argued that an email is a written notice when you can prove that someone received it. But the best practice is don't even risk that. That's an argument that's evolving based on our digital world, and depending on which county you're arguing it in and before which judge, it may or may not fly. And the error, that in this area of law, we err on the side of the tenant. The tie goes to the tenant. So don't even risk that. If you're a landlord and you want to terminate a lease, you need to, number one, or tenancy, you need to check and see whether you can even do that. Number two, provide proper notice. And that's something that's not new. That's never changed, but I just see people not doing that. So I want to make sure everyone is aware of this. The same one thing that hasn't changed is that if you breach a material term of the lease, you can be given a 10-day comply or vacate notice by a landlord. And if you fail to comply, and if it's a legitimate breach of a material term of the lease or the tenancy, whether it's a written lease or whether it's just the tenant's responsibilities established by statute, that right that the landlord's had to comply, to push, comply, or vacate after 10 days is really is sacrosanct. It remains. There's also a 3-day issue comply or vacate for waste. Which is not just a breach, but something that damages property or damages the value of the parcel. Very broadly, I'm sure any attorney knows that there's a little more in depth to that, but it's a difference between breach and waste that's important for landlords and tenants to know. One of the interesting things that the legislature did for some of these other causes, I mentioned landlords' needs. They did build in some understanding for smaller property owners. If an owner or the family or a family member of the owner needs to occupy a space and there isn't another comparable available space in that building, then with 90 days notice now, the landlord can require the tenant to vacate. But that 90 days is certainly significant. That's a quarter of a year. And that also requires that in a timely manner that someone, either the owner, if it's the owner who needs to occupy it, or a family member, occupy that place for at least 60 days of the next 90 days after the tenant vacates. Or the owner could be liable for a wrongful, not eviction in this case, but a wrongful termination of the lease, and there's significant penalties for that. There's also the 90-day advance notice for sale of the property that can terminate a tenancy. This is similar to what we saw. We saw a great number of evictions, or at least a great number of terminations and several evictions due to sale of property during COVID. That was a 60-day notice that's been extended 30 days. That doesn't require the landlord to sign an affidavit or anything at this point anymore, but it does require reasonable efforts within 30 days after the tenant vacates. Otherwise, the tenant can come back If the landlord doesn't list at a reasonable price, if the landlord withdraws a unit from the market or rents to someone else within 90 days, that's again a wrongful termination, and there are penalties for that. Other reasons for demolition, conversion to condos, a lot of these require 120 days written notice, again, either served directly or posted and mailed. A condemned unit has a 30-day notice requirement. There are transitional housing requirements, if someone needs to transition out. But there's, a lot of these really are not surprising. Other things the legislature did that are kind of interesting along the lines of the family needs is that if someone shares a kitchen or bathroom, if a landlord shares a kitchen or bathroom, they only need to provide 20 days notice to require a tenant to vacate if it's a periodic tenancy, or 20 days before the end of the rental term if it's a written if it's a written lease and the term is about to expire. This actually there's been some conflict, and I've actually had to deal with this a little bit between the family provision, the owner or family occupied provision, or the shared kitchen provision, where one of those is a 90-day provision. The other one of these is a 20-day provision. If you have someone who shares a kitchen and a bathroom with a tenant, and then that tenant's renting a room in the house, and the owner says, well, my cousin needs to move in, or an immediate family member, my brother needs to move in, he doesn't have a place to live, so this is a shared kitchen and bathroom situation, you need to leave within 20 days. That tenant might come back and say, actually, I need to leave within 90 days because that's a family occupying situation. My argument is certainly that the 20-day provision applies. It's not clear to me, and maybe someone could shed light on this, which one of these trumps the other one. The argument from the tenant's perspective is that this statute is heavily, the entire statute, 5918, the entire chapter heavily favors tenants and defers to tenants. With a strict interpretation, then it might be 90 days. Fortunately, I didn't have to resolve that in court, but that's a big question that exists right now. And I think it's particularly relevant to landlords in Jefferson and Clallam counties, because at least as I believe I've seen, the majority of the landlords, or at least if they're not living with their tenants, they have smaller units. They may have family members in the area who might need, in light of the way the market's looking right now, to move in. So it's a good idea to try and avoid this problem in the first place, and not have to bring it to court. But think about, if you're leasing a space in your home, you need to think about planning ahead at least 90 days just to be on the safe side. Even if you do share a kitchen or bathroom, because this hasn't really been resolved or addressed. Certainly, if someone has an idea, please chime in.
I have some questions here, Sam, if you have a moment.
Sure. Yeah, go ahead.
One question is, for tenants who are currently in tenancy at will month-to-month rentals, like where the initial 1-year lease has long passed and the tenant just continued paying rent, what is the benefit to that tenant to enter into a new 6 or 12-month lease with the landlord? It sounds like doing so merely gives the landlord the option to terminate without cause at the end of the new fixed term.
Oh, sure. In that situation, the tenant would certainly, understandably, if you're already in a situation where you have a month-to-month, or you have a lease that's gone month-to-month and it's well past any period of termination, I don't know why you would sign. So yeah, that would be an exception. My comment was really intended to talk about a brand new lease or a brand new tenancy. But if you've already gone month-to-month, you're going to be considered a periodic tenancy, and I don't see any reason to that a tenant, from a tenant's perspective, you'd want to do that, unless you want to, if you want to change the terms of the lease for whatever reason, or the terms of your tenancy for whatever reason, that might be something your landlord requests. And if I were advising the landlord, I'd probably say, well, if we're going to agree to change the terms, I need you to agree to a written lease.
Okay.
But no, that's a good point.
A couple other questions. What is considered evidence of a wrongful termination in the case of a landlord not moving back in And does follow-up happen through law enforcement or some other pathway?
So as to the first question, the law sets out a standard where the landlord or the family member that's supposedly reoccupying the space needs to spend at least 60 days of the next 90 days after the tenant has vacated within the property. Now, what would be evidence of that is really a fact, case by case factual question. So I can't give really specifics about a particular case, but if it's obvious that nobody's living there, if you have neighbors who say, oh yeah, they moved out and we've never seen a car there since, if you know that person has a public address somewhere else, that might all be argument that the landlord did not in good faith move out, and that creates a presumption. If you show that hasn't happened, that creates a presumption that it was a bad faith termination of the tenancy, and that creates a presumption that it was a wrongful termination. As far as how follow-up would happen, this is all a civil process, so it's not, law enforcement doesn't do it. I would believe, and because I haven't really delved into how you enforce this, you could go to an attorney, ask them to send a nasty gram letter and say, hey, you owe this much money because of a wrongful tenancy, and how much you owe depends on the circumstances. I'm not sure, and maybe Steve can answer this, whether any of the new resources are being devoted to enforcement. I can tell you, at least under COVID, not under the new law, there was the Attorney General's office actually had people actively intervening and threatening people with significant penalties that I presumably the state would have followed up with for violations of the governor's proclamations. But Steve, are you aware of any, or is Northwest Justice Project making any effort to enforce wrongful terminations?
Well, we haven't crossed that bridge yet, but I would imagine that would, I'm just speaking off the top of my head, I would imagine that would be classified as fee generating, which we're not allowed to do. But we haven't really dealt with that particular issue. I would tend to think it's going to be the individual former tenant's responsibility, but that's just my thought.
Yeah, so I'm not aware of any public resources that would help you enforce that. But certainly, sometimes when we write letters on behalf of tenants who've been forced to move out wrongfully, I would say you could be held liable for my attorney's fees. You could be, depending on the circumstances, you can be held liable for certain statutory penalties on top of those. And so there's if you can reach out and you can find an attorney with time, that attorney may be able to help you. It's not really something that we typically do on contingency, or at least I don't, because you never know what's going to come of a situation. But yeah, so hopefully that answers the question. So some of the other reasons, for termination, the biggest latitude that a landlord has here is for a provision under the statute that allows, with 60 days notice, with basically a good economic or business related reason, to terminate. As long as they provided 60 days prior to the end of the rental term or prior to the end of the rental agreement. And it has to be a legitimate economic or business reason that isn't, a family reoccupation, isn't a condo conversion, isn't demolition of the unit, isn't sale of the property. The court, however, when you terminate on this basis, if the tenant doesn't move out, usually the court will provide a writ of restitution at the show cause hearing if the tenant overstayed unlawfully, and then the sheriff's office usually tries to enforce that within 10 days, and then tries to, if they can't, another 10 days. The court has the power under the new statute, if a landlord says within properly provides notice, says, hey, you need to be out in 60 days, I just can't continue on with this anymore, here's why. And the facts, I should note, the facts of each of these has to be laid out, not just referencing the statute, but the actual reasons need to be laid out within the notice, which is something that, attorneys for a long time, and I'm guilty of this, would sort of just shorthand, we'd say, well, under this provision of the statute, you need to be out. That we, in these circumstances, whatever the cause is, you have to provide the tenant with enough facts that they understand the basis, and they can look at the statute and say, well, I'm not sure this lines up. Maybe I need to call a lawyer. Maybe I'm just gonna, or maybe I'm ready to represent myself. But fortunately, you won't have to do that if you qualify as indigent. But those facts need to be laid out. But I digress. So that economic or business decision, a legitimate good cause, can move forward. It is a basis to terminate within 60 days notice. However, again, the court can prolong that process much longer. They can stay the writ of restitution for 60 days, and they can condition that upon the tenant paying rent, and then awarding costs and fees. It is something that the court has to do if they do stay the writ of restitution if someone's evicted for legitimate economic or business reasons for the landlord. And there's some other bases. If someone fails to register as a sex offender, if someone sexually harassed either the property owner, another tenant, or an employee or agent of the owner, if they fail to sign a new lease, when they're provided a new lease 30 days prior to the expiration of the current rental agreement. If they misrepresent facts that are material on their tenant application, that would either cause a landlord to say, no, you can't rent, or would cause a landlord, and they have to be, legally valid questions. But if they would cause the landlord to say, well, I need more information before I make a decision, that's another basis with a 30 days advance written notice. Now, all of this stuff is under, I'm kind of just listing stuff in the statute. It's really important that landlords at least look at and understand the basis for eviction in RCW 5918-650. It's just really critical. And I mean, it's important, obviously, to follow the law, but to not put the added stress in this business relationship of, oh, I'm going to make you move out when you don't have a basis to do so, can really come back to bite you, and it doesn't help with your business relationship with your tenant. It's also, for those reasons, it's also very essential for a tenant to understand, and that's, I think, what the effort was here by the legislature, is to make sure that these causes are laid out clearly for or as clear as someone writing legislation can do, and that people understand the causes for ending these, and that they be laid out even when the landlord's trying to terminate. The other thing that's notable, and this is where they've kind of made the Residential Landlord Tenant Act mirror another law related to mobile home parks. If you have a certain number, I think it's 4 violations within 12 months that are breaches of the lease, even if a tenant has cured them, they've been given those 14-day comply or vacate notices. If there are 4 of those in 12 months, the landlord can then terminate the tenancy with 60 days notice. So I know that's a lot of information I've just downloaded, but I think the big takeaway for landlords here is that a written lease is the best thing to protect you. For a tenant, if you're on a periodic lease, you're in a much better situation than you were prior to this law. You are no longer risking that 20-day. I think the 60-day provision for business or legitimate economic reasons can be very broad for landlords. So that's one thing to keep in mind. But really understanding these changes is critical if you're going to sign a new lease, or if you're going to, whether you're a landlord or a tenant. But I'm happy to take other questions. I don't know if there's further time. I think I've gone over my time, but I'm happy to take email questions as well.
Thank you, Sam. I don't have any questions in the chat right now, so I'm going to turn it over to Cherish to tell us about some of the resources that are available in our community for landlords and tenants.
Thanks so much, Stephanie. I appreciate it. And thanks everyone for being here. So again, I'm Cherish Cronmiller, the Executive Director of Olympic Community Action Programs, your community action agency for Jefferson and Clallam counties. I see that, today we've got a number of individuals who aren't attorneys, and I can only assume that you all are here to want to be sure that you know how tenants can be able to be getting rental assistance and landlords getting that assistance. Know that, if you contact our agency and talk with one of our case managers, if you've ever already been served with notice or have some court documentation, we are going to direct you to the NJP line to make sure that you're calling and getting right to counsel. If you're having some other dispute that really would be better served in dispute resolution, we're going to send you over to Peninsula Mediation. Let's see, Stephanie or Shauna, I need to be able to screen share. It says it's disabled for me. So while they're fixing that so that I can screen share, there we go. So just quickly, I've got some information here for folks to be able to see. Now, everyone's been hearing about TRAP, right? TRAP, which is Tenant Rental Assistance Program. And that was a federal program that funneled to the state and then funneled to the lead agencies in most of the counties. And the lead agency in Jefferson County is OLICAP, lead agency in Clallam is Serenity. But the information I'm going to give you today applies for both these counties and really all of them. So keep in mind that rental assistance has been difficult to get out the door because the Treasury program really had a lot of rules and regulations set with it. And you see here, there were a number of forms that needed to be completed and done in order to qualify for assistance. And here, this is a page off Serenity's website, very similar to ours, talking about what's available and what you need to provide. So if you go to our website, OLICAP Housing as Services, and I'll provide, when I'm done speaking, I'll provide some links, and some of that was provided to you today earlier. But right off the OLICAP website, we have documents for you to be able to print, including, we have them in English and Spanish, the household information and eligibility form, the payment agreement form, which your landlord has to sign, or if the landlord is applying, you're going to be filling out these forms. And then the W-9, which is necessary in order to put you as a vendor into our system. So we always need to have those W-9 forms done. Often landlords are leery potentially of filling out a W-9. They realize that obviously this is going to potentially be reportable income to the IRS, right? And so, but we have to do this based on the rules and regulations of the programs and the money that we're providing. Where landlords often, fall short is they don't know how to fill out this information. If you don't have a business, you're just an individual, you're filling out your information. This is where we're going to send our 1099 form of all the money that you've potentially received for our agency that you're going to turn into the IRS and deduct all of your costs of potentially being a landlord, right? Make sure you put in your social security number. If you have an EIN number, don't use your Washington number, okay? So your Washington business number is different than your federal tax ID number, okay? And not all, unless you have a business, you would really have no reason to have the EIN number. So, and then make sure you sign and date the form. That's another big thing that we often fall into. We have landlords turn in stuff to us and they haven't filled out the forms. And then I give some links to some of where those forms are. Now, what Washington State has decided is that because it's been so difficult to get the TRAP money out the door, Washington's going to revert back to its ERAP program, which is the Eviction Rental Assistance Program. And the reason for that is to increase the flexibilities of the funding, okay? Because the TRAP program wanted to be sure there was a clear nexus with COVID, wanted to be sure there was specific documentation. And so The ERAP is going to be easier, and it starts October 1st. So you're going to see some of these forms changing between Serenity, our agency, any other agency for some of the other counties. And some may say TRAP, some may say ERAP. Don't worry about that. Just get the forms filled out. That's the number one thing, is communication and getting stuff in writing, right? So the funds are going to be available through June 30th, 2023, but that doesn't mean that you should take it easy, okay? You want to get in line for these funds, all right? And so the start date is going to be October 1st. If you've already applied through our agency or Serenity, we're going to go ahead and cue you into the best pot of money that we need to utilize, okay? And here you can see why Commerce is ending TRAP, because of they kept changing the reporting requirements, they kept changing the documents on us. It was pretty complicated. And Washington State Commerce they're really great at acknowledging this and working with the local providers to make sure that things are easier to understand and money is getting out the door. So you can see here some of the differences in eligibility and documentation. And so currently to qualify, you have to be at 80% AMI or less. And those figures are on our website. If you're close to that, look at the form, fill out the information, and we'll let you know that, because sometimes there might be some other pot of money that you might qualify for. And so we just never know. That's always changing. So also it'll allow for self-certification, and it too will still allow us to go back to March 1st of 2020 for rent arrears. It'll also allow us to go forward for future rent payments too. In all these programs, right, we make the payments to the landlords, not to tenants, right? We never put money in the hands of tenants. It always is going to the landlord, which is why it's important to have this documentation of some type of lease agreement, or the fact that you've been living there, however we can best document that. So quickly, those are some of the tenant-based programs. And in order to qualify for those, you need to be an actual tenant in that place. If you've already left there, you're no longer a tenant, and you're not going to qualify for those funds for that back rent. Instead, the landlord now needs to apply. So if the landlord did a soft eviction or whatnot, talk the person into leaving out. Commerce has these landlord relief programs, okay? Now, all of these programs are with Department of Commerce. They're not any of the local agencies, okay? And so I give the link here, and I can provide some more of these. And there's a couple different ones depending on when is the unpaid rent, how many properties do you own, is the landlord low income? So all of that plays a role here. You can see, okay, that so far we haven't had any landlords in Jefferson County apply for the funds up until the last day they have data. We've had about 17 landlords in Clallam apply. But you can see that there's a lot of claims requests, fair amount that's been approved, number of denials, right? And what are the denials for? You're missing the repayment plan for a current tenant, or the charges don't qualify. Again, it has to be the rent. It can't be any late charges or some of these other fees or fines that you've maybe added into your rent agreement. It is strictly to try to make you whole again, as if, God forbid, COVID hadn't happened, right? And so it's trying to put you back in that position. And then because this is a state program, right, you need the state vendor ID number. So when you go to the website, it will prompt you, if you don't have a state vendor ID number, to go and fill that out. Why do you need that? Because you'd be like, well, why can't I just provide my social security number, right? Or something like that. Well, it's no different than when you apply for services at our agency. We need to have your W-9 so that we can put you as a vendor into the system. Same thing with Washington State. They need to put you as a vendor in the system so they can issue you a check. So that's why you have to go through, the going and getting, one of those. Now, tons of different types of rental programs out there. So just bear in mind that the number one thing to do for tenants or landlords is communicate, start your research, reach out and find out what's available. Because if somebody, has needs that are long-term, then we want to ensure that we are making that happen. I want to switch over and share my other screen just to show you some of these websites. So this is the TRAP, and the ERAP form will look very similar to this. You see that, and again, this is back to whether the landlord's applying on behalf of the tenant or the tenant is applying. Again, the tenant still needs to be in the actual location. And the rental information, rent request information, total rent payment. And so this is where some of you that are on the line as our partners can really help people figure out some of these forms and help fill them out, okay? That's necessary. Same with all of the other unpaid rent forms that are available too from all of these websites. I know some people have to go. I'm always available to come and speak and provide more of this information if anyone's interested. This is the unpaid rent repayment worksheet plan that's off the Attorney General's office. That is needed pretty much for any case that you're going to do, whether it's getting repayment and money back, or you're trying to prove your case to the courts about what's unpaid and what those amounts are. Read the directions. They tell you very clearly what you can include and what you can't. So I want to leave time for questions. I know this is very, very quick and fast, but the most important thing is going to our websites, looking for that information. And again, I'll share some more of those links. But if anyone has some questions, I'm happy to stay on and answer those.
Okay, thank you, Cherish. That was a lot of information from all of our panelists. We have all three still on the line, so if anyone has any questions, now's the time to ask them. We do have one question here. Do you know of any programs that help pay for damages to the property after the tenant moves out during this time?
Yes. So Commerce has a tenancy preservation program, and there are some where if there have been damages, you can attempt to get those reclaimed. We also have like a home loan repayment. We have a home loan repair program available at our agency if the landlord is low income. A lot of these are based on the landlord's income too, if you're going to get help with some of those repairs. But there are some preservation programs. Again, you want to document, you want to get good estimates of those repairs, take pictures, because you're going to have to prove potentially that those were caused by the tenant and not pre-existing.
I don't know if this is a question. It says reasonable terms is the question. So I think maybe that's just a statement. If there's a question related, maybe clarify a little bit.
There was a question that seemed a little specific. I was just going into the Q&A and typed an answer about terms that require someone's heirs to be responsible for their lease for any debts. I can tell you right now, I don't think that's enforceable at all unless your heirs are signing on as co-signers to your lease. I don't like to make broad pronouncements about terms in a lease if I haven't seen the lease and know the circumstances. But if you have incomplete sentences in your lease, that's really going to be up to the court. If it got to court, the court interpreting what it means. There are all sorts of laws called canons of construction and other case laws that lawyers and courts use to determine what something means, or to prove what something was intended to mean when it was written. And they teach entire law courses on that, and I've forgotten a good deal of it. But so we look it up every time. So I can't really answer that. But as far as making heirs responsible, that would probably be something that that person would have to sign on. So it sounds like a landlord's trying to get a co-signer without actually having a co-signer, and I don't think that can fly. This sounds like a situation where I'm not sure, correct me if I'm wrong, it's an anonymous person, but it sounds like there is already a periodic lease or a periodic rental, and the landlord's trying to get a lease agreement, which the landlord may or may not be entitled to, depending on what the circumstances are. But those terms it's clear they have to be reasonable under the statute. I would tell you, I don't think it's responsible to make your heirs responsible for your debts. I also don't think it's enforceable. But that's, with all the scare quotes that attorneys add, including it depends on the circumstances. But it sounds like a very strange situation indeed.
Carol, OLICAP and Serenity doesn't typically help landlords with some of those forms with Commerce. That's what, Commerce hasn't provided us any admin or operating costs and didn't for TRAP. So that was part of the problem. Commerce does have some phone numbers and things like that for people if they have questions. But honestly, the forms are pretty easy to use, pretty self-explanatory. If you can drag and drop documents, pretty simple and straightforward. But Commerce on some of their links does have who to contact. You can see here on one of these mitigation sites, they have a staff person assigned to helping to handle that. And so for those forms, you'll want to contact Commerce because those aren't our programs. We're going to focus heavily and have been on just trying to get money out the door, right? And that's what we do. So if partners, landlords, whoever can help us get the forms filled out so the file is complete, so we can cut that check, that's fantastic. And, we have to constantly remind tenants that they shouldn't just leave because the landlord is telling them they have to, per se, right? Especially when they're in the process of, we're in the process of processing your payment, right? And we have had situations where checks have gone out and, tenants sadly have already left the tenancy, the rental. And we hate to see that happen, especially because, these laws and those of us that fought hard for some of these policies was to ensure that some of these evictions didn't happen, or these soft evictions. So just because something looks official doesn't mean that it is. So make sure you're talking to NJP, contacting Peninsula Mediation, or us, so that we can let you know that, hey, regardless, we want to make sure that we're getting this money in our community, right? In Jefferson and Clallam, there's millions of dollars. And so we want to be sure that's getting out there, and that's doing the best we can with filling out these forms.
And I would add to that, if you're a landlord and you're just getting impatient and the payment's not coming, you need to be sure that someone's not abiding by whatever repayment agreement before you pull the trigger and even threaten to make someone leave, because there are still potential consequences even if you don't file for eviction.
We do have a question. Maybe Sam, you can, or actually Sam or Cherish can answer this. My landlord raised my rent in October. Is there money available to help me pay? Yeah, so this raising the rent is a big issue right now, right? And the language says it has to be reasonable. And I think, as Steve mentioned on one of the other CLEs or calls we had, that's yet to be litigated to see what's reasonable, because there is no percentage per se. And that's really what would be the best thing, right? Is to say, oh, you can't, do more than a 10% increase each year, blah, blah, blah. That doesn't exist, but it should be reasonable in light of what your rent amount is. So I don't know what your amount is from 150 additional. We can potentially help with some of those if you qualify. We do have other rental assistance programs through the county. In Clallam, it'd be Serenity that you want to contact. There's consolidated grants, there's rapid rehousing grants, there's, a lot of different money. And so, be sure to also communicate with your landlord and let your landlord know, like,
hey, you're raising the rent, but I can't afford this. And if that means, sometimes sharing that you're on a fixed income or things like that, that's good. That's good communication, to have that record that you informed your landlord that you're going to struggle with this. I'd also say if landlords want to, increase rent amounts, things like that, there are programs through the Peninsula Housing Authority to potentially qualify for Section 8 vouchers and become a housing qualified, home under that program, under federal HUD programs. And so there are some options out there. But I would say communication is key. And I would really warn some of the landlords against trying to, jump these rent amounts when you don't have clear reason, right? As an attorney, I would be arguing like, well, why did you raise the rent? Is it simply because that's the amount you can get? Or do you have actual cause, damages, or charges related to why you're increasing the rent? The fact that you can just get that amount, I don't know how much water that's going to hold, especially when you're dealing with somebody on a fixed income who's disabled. How's the court going to look at that? So that's a situation where I'd say I think you should call the clear line and have that conversation. That's unfortunate, but we are seeing a lot of that. We're seeing landlords who are incentivizing tenants to leave. They're literally paying them off to leave. And all I can tell folks is that in Jefferson and Clallam counties, there is no rental housing to be had. There's like a 0% vacancy rate. Do not leave your rental that you're in. Even, I know when somebody offers you $1,000 or $2,000, it's hard to say no to that. But we don't have any places to put people. I've got rapid rehousing dollars. I literally have no place to put folks. So those funds are going unspent. So make sure you have someplace to go before you ever decide you're going to leave your current rental. We also do have mortgage assistance. Let me say quickly, we do have some mortgage assistance available. If it's COVID related, you've had a loss of income. This is through CDBG-CV1 and 2. And we have this in Clallam and Jefferson County. So if you need some mortgage assistance, reach out. Let's see how we can help you that way.
I would also, just to add, I agree with everything Cherish just said. Just raising the rent is a change to, is typically a change to a lease agreement or a verbal month-to-month agreement, and that could constitute a termination. So it might be worthwhile to talk, if you can reach Northwest Justice Project and they're available, or pro bono attorneys, to get an attorney to evaluate whether that's even lawful. That was the first thing that popped in my mind. It was, whoa. And I've had people say, well, I want to raise the rent. And I said, well, you have to do certain things first. And yeah, so I would definitely talk with an attorney about whether that's even lawful for your landlord to do.
Thank you, Sam and Cherish, for those answers. I think we're going to go ahead and end our program. On that note, if you have other questions that weren't answered today, you can email probonoloyers@gmail.com and we'll forward those questions to our panelists. And then we have in our chat a link to the donation portal if you want to make a donation to CJC PBL for hosting this presentation today. We would appreciate that. And then just a reminder for the attorneys, don't forget to email me your name and bar number so I can get your CLE credit once we get that approved by the WSBA. And yeah, and a lot of information went up in the chat. So if you missed any of that, feel free to email us and we will get that information to you. And with that, I'd like to thank everyone that attended and our panelists, and we'll close out our program.